Obligations are, what your rights are, and then see how you wish to respond. On this request and warrant, it alleges 4 counts of violating the terms and conditions of your probation. Count 1 alleges that you violated special condition 2.0, which requires that you must not use or possess alcohol or other intoxicants. And more specifically, it's alleged that on or about February 3rd of this year, you used and or possessed alcohol. Count 2, 3, and 4 each allege a violation of Rule 1. Rule 1 of your probationary terms requires that you are not to violate any criminal law of any unit of government. For count 2, it alleges that on or about February 3rd of 2026, you operated a vehicle while intoxicated and or impaired. Count 3 alleges that on or about February 3rd of 2026, you operated a vehicle without insurance. And count 4 alleges that on or about February 3rd of 2026, you possessed open intoxicants in a vehicle. You have the right to challenge those 4 allegations at a contested hearing. That hearing would occur within 14 days from today's date. At that hearing, you'd have the right to be represented by an attorney, as well as at all subsequent proceedings. You'd have the right to have the prosecutor prove the allegations by a preponderance of the evidence. You also would have the right to review the evidence against you, question or cross-examine any witnesses presented against you, as well as the right to present witnesses, evidence, or testimony if you chose, and also the right to remain silent and the right to not have that silence used against you. If you cannot afford an attorney, the court will have a public defender appointed to assist you. If you're found to be in violation of your probation, you'll be resentenced on your original offenses. In this case, you were originally convicted of aggravated assault. That is a misdemeanor. Misdemeanor punishable by up to 1 year and or up to $1,000. You were also convicted of attempting to resist assault or obstruct a police officer. That would be a misdemeanor punishable by up to 1 year and or up to $2,000. And you are also convicted of malicious destruction of personal property in a value of less than $200, which itself is a misdemeanor punishable by up to 93 days and or up to $500, or 3 times the amount or value of the property that was damaged or destroyed. Because there are 3 non-technical allegations, the court is not limited to a sliding scale. For what are called technical probation violations, the court is limited to a sliding scale of 5 days, 10 days, and 15 days for your first, second, or third. However, because you are charged with 3 non-technicals, if you were found guilty of 1 or more of those 3, the court again would no longer be limited by the amount allowed. Would not be limited by the sliding scale, but would only be limited by the amount allowed under the law for the 3 offenses. Now, based upon these allegations, I suspect you have been charged criminally in another courtroom. Mr. Van Atwell, do you know if there have been any new charges filed based upon these alleged acts?
He was arrested on the 3rd, but released on a PR bond because he had to get evaluated medically, and he has court in 85th District in Benzee on 219.
Okay. All right.
So he's charged, but he's
On bond.
Yes.
All right. So, Mr. Rocheleau, that means that if you request an attorney, I'll of course have one appointed, and I'll enter a not guilty plea. If I enter the not guilty plea or you enter the plea of not guilty, either way, we'll set it for an informal hearing. That hearing could take place later this week. However, I will tell you that I have a trial that's going to probably take the full next 3 days. So there's a good chance we wouldn't get to it until next week. At an informal hearing, the attorneys and you and Mr. Van Atmel will appear in front of the court and tell me what's going to happen. Are we going to have a contested hearing? Is there going to be a plea or resolution, or are the allegations going to be dismissed? I won't know that until we get to the informal hearing. Now, if there is no resolution at that informal hearing, we will have it set for a contested hearing, which is again in the courtroom where there would be witnesses. Generally, those take about 30 minutes to go through. Also, you want to keep in mind that anything you say today or in the processing of this case could be used against you in Benzie County. So you want to be very careful about not making any statements today that would be inculpatory or could be used against you. Now, so far, do you have any questions about what I've advised today?
No, Your Honor.
And do you wish to have the court appoint an attorney to assist you?
Yes.
The court therefore enters a not guilty plea on behalf of the defendant and will refer the matter to the Western Misaki Public Defender Program for the appointment of an attorney. Now, the next question becomes, what does the court do with the defendant in the meantime? Mr. Allshu, I've been told that you had some kind of medical appointment or something. Have you had, or you needed one? Did you have that already?
Yes.
Right, and are there any other appointments set in the next week?
No, Your Honor.
All right. Your position, Mr. Van Atmel, I don't know if he's had any other probation, but I don't see any tabs here, but in the file, but have there been any other probation violations?
There's one prior PD acknowledgement for failure to pay fines and costs.
All right.
He did turn himself in to the probation department on the 6th,
Okay.
last week Friday, expecting to go to jail. So
All right.
just based on that, I would not be opposed to some type of bond.
Mr. Oshlu, what is your bond out of Benzie County?
I'm not sure. They just gave me a ticket and then gave my belongings, and then and that was when I was in Munson Hospital, so I don't know.
You told me there was a PR bond. Yes, I'm sorry. Mr. Van Atmel had already told me that. Thank you. Did they have you sign up for breath tests or anything else like that?
No, Your Honor.
Are you still residing at this address on 39 Road up in Manton?
Yes, Your Honor.
Are you working?
Not anymore.
Okay. And with whom do you reside at that address?
My sister.
Do you have any prior drinking and driving convictions? In other words, it
Yeah.
tells me if it's all right. And so up in Benzie, are you charged with a drinking and driving first, second, or third?
Second.
So does that mean you only have one prior drinking and driving?
Yes.
All right.
As far as I'm aware, he has one prior, which occurred prior to his placement on probation in this case.
Yeah.
But it was resolved while he was on probation in this case.
Okay. That just tells me, Mr. Oshler, that you aren't facing a felony. That's why I was asking that question. Okay. What were his guidelines here, Mr. Van Atmel?
There's no sentencing guidelines. You know that.
Oh, it's right. It was a misdemeanor. Thank you. Well, all right, the court will set a bond in this file at $500. The court will add the terms or conditions that he is not to use or possess any alcohol or controlled substances. And that he'll be subject to random testing through the Community Corrections Office. Also, he must enroll. Well, we're gonna get this generally done within a couple of weeks. EOP program probably wouldn't even be advisable because you wouldn't get it into it before this was resolved. So, all right. I'm not gonna add any other term or condition. He's not to consume or possess alcohol or other intoxicants and be subject to random testing through community corrections. All right, anything else, Mr. Van Atwell?
Okay, thank you.
All right, Mr. Rochelu, make sure, I'm sorry, is your telephone number, sir, still the one that ends in 6355?
Yes, Your Honor.
Thank you. All right, we are adjourned.